Does signing Disney's terms of service mean that they can't be held liable for murder? If you order DoorDash, does that mean you can't sue them even if you get run over by one of their drivers? Does pressing I accept on Facebook's sign-up page mean that they can't be held accountable if Mark Zuckerberg punches you in the face? Okay, we're getting a little outlandish with the examples, but they do highlight one thing. There are a lot of misconceptions about what this lawsuit right here is and what it isn't. So, let's break it down. So let's start off with what the lawsuit is. As explained in the original 19-page lawsuit, on October 5th, 2023, Kanokporn Tangsuan dined with her husband and her mother-in-law at Raglan Road in Disney Springs. According to the lawsuit, this restaurant was chosen by them specifically because of the fact that Disney and the restaurant had advertising that they held food allergy accommodations as a top priority. The lawsuit explains that they killed a medical doctor. Dr. Tangsuan and her husband explicitly informed the waiter about her dairy and nut allergies and confirmed multiple times that the food served would be allergen-free, despite being assured that the food was safe for Dr. Tangsuan to consume. Within the hour, she suffered an anaphylactic reaction and she did not survive. And the medical examiner who examined Dr. Tangsuan's remains cited anaphylaxis caused by elevated levels of dairy and nut allergens in her system as the cause of death. 4 months later, Dr. Tangsuan's widower filed a wrongful death lawsuit. The lawsuit itself has 4 counts that are all fairly similar: negligence against both defendants, and a negligence claim for actual agency against Disney with respect to its relationship with the pub, and a negligence claim for apparent agency between those two entities. Digging into those nearly identical negligence claims, among many other things, they accused them of failing to educate and instruct the employees on how to make sure that the food was allergen-free, and failing to warn Dr. Tangsuan that her food was not allergen-free. All of these claims were brought under the Florida Wrongful Death Act Section 768.21. And to get very specific here, there's a negligence count against the pub, and there are 3 very similar negligence counts against Disney. The counts against each entity also contain these specific claims for the following types of damages: the widower's pain and suffering in the past and his future pain and suffering because of the death of his wife, her lost income, her lost companionship, the value of her as a partner in the home, funeral expenses, the lost earnings on her saved income, medical bills, his reduction in earnings due to grief, and dealing with her death. It might not come very naturally to you to think about what is someone's death worth, but this is actually the way that the legal system handles these claims. You have on the one hand the profound loss of a person, a member of a family that people loved and relied on, just gone and never coming back. And then the lawyers break it down into these discrete elements of potentially like dollar value categories in terms of what a human life means in the context of the lives of their family members. It's tough. As an aside, the agency arguments are simply a way of saying that from a legal standpoint, the pub might be a virtual, if not an actual extension of Disney itself. And so the lawyers have framed the claims to account for that element of the legal relationship possibility between the two entities. With all of these claims for negligence and all of these different types of monetary damages, you might expect the lawsuit to have a dollar value plugged into it, like, I'm suing you for $5 million, or I'm suing you for $20 million. But most wrongful death lawsuits are not like that, and this one here, this is no exception. The widower, on his own behalf and on behalf of the estate, is not asking for a specific sum of money. Yet, that time will come. Now, on to the reason that this case has made several headlines, and rightly so: Disney's strategy. Actually, its third strategy, because originally Disney answered the lawsuit, actually several months ago, not long after they were served with it. And they raised all the normal defenses, which, if you take the legalese out of it, is simply to say, it wasn't me. And then they later amended that answer not long after that, but then they recently took their third bite at the apple, which instead of being an answer, was really an affirmative motion in which they were asking for something from the judge. In their 16-page motion, Disney asked for 2 things from the court. First, to compel the plaintiff to arbitrate the claims, and second, to stay the legal action pending arbitration. Now, under most circumstances, arbitration is used by businesses to keep the right to a jury trial away from customers. The argument that they make is that arbitration is faster and less expensive and private, and therefore it's to be desired. But come on, that's not why businesses like arbitrations. They want it to be a secret so that they don't get bad publicity, and they want to be the party who pays the private judge who's hearing the private claim. So why does Disney feel like this is an acceptable route in this lawsuit? Because before filing the lawsuit, before even visiting Raglan Road, all the way back in 2019, Jeffrey Piccolo, Dr. Tangsuan's widower and the personal representative of her estate, agreed to Disney's terms of service by signing up for Disney Plus. And then in 2023, he bought tickets to Epcot. According to Disney's motion, the terms of use, which were provided with the subscriber agreement, included a binding arbitration clause which applies to all disputes, including those involving the Walt Disney Company or its affiliates. WDPR is an affiliate of the Walt Disney Company. Now, before we jump into my thoughts on the strategy, let's break down how terms of service are normally used. Companies are all the time making you accept in bulk their terms of service. We've all seen it. And I mean, it's not like it's a real negotiation. You click on the button embedded in a web portal or in a sign-up process, and then you get confronted with a large batch of terms. And you don't just pick and choose, you just have to accept all of them if you want to go forward. And because of that seeming inequality at the bargaining table, courts try to be careful to make sure that the customer has actually seen all the terms. Not that the terms are fair and not that the customer has read them, but that each of the terms was communicated, disclosed, and that the customer at least had a chance to walk away. That's been a threshold issue for courts now for about 3 decades. Was the customer apprised of the terms of service and had a chance to take their business elsewhere? If we're gonna do a flashback to the 90s, let me tell you how this all started. Software companies used to sell software on CDs. I know it's crazy, but that's how you used to get them. And they're wrapped in that plastic. Inside the plastic, which you would tear open, there would be a contract. And the first words of the contract would say, by tearing open this plastic, you have agreed to the following terms. But you couldn't see that contract until you torn the plastic open. That issue percolated up through the court system, and the judges said, no. We're actually not gonna do it that way. We are gonna make you disclose terms before people are bound. And that's one of the things that happened in the 90s. So again, Disney is saying that because the widower signed up for the Disney Plus bundle a few years ago, and because he bought some tickets to go to the Epcot Center, also online, that he has waived his right to a jury trial for the death of his wife. With this background information in mind, we can finally talk about Disney's strategy. Now, Disney is famous for their numerous, brilliant lawyers. But is this game plan too far? Is it too crazy? Is it too crass? Well, we know what the plaintiff side thinks of the strategy. They said, basically, to summarize, this is crap. In sum, there were 3 main reasons that they brought up. First of all, the Disney Plus terms of service were not properly linked to the sign-up process, such that no user could know that they were waiving the right to a jury trial by signing up, because you couldn't even see those terms even if you wanted to. Next, Mr. Piccolo argues that the purchase that he made of tickets to the Epcot Center created an obvious ambiguity as to whether all disputes must be resolved by arbitration, because the terms of service of that ticket purchase, which were visible to the customer, talk about the parties suing each other, if they need to sue each other, in Orange County, Florida Circuit Court, which is exactly where he did sue. And since the terms are ambiguous, and since Disney wrote them, then the ambiguity should be resolved in favor of the customer, since he didn't write the vague and unclear contract. Furthermore, the plaintiff has argued that the signed terms of service can't be used against him as a defense in this lawsuit in court because they were signed by Mr. Piccolo as an individual person. But the lawsuit was filed by Dr. Tangsuan's estate with Mr. Piccolo as its representative. We need to really focus in on this for a second. Do you remember that bizarre quote from Mitt Romney from way back in the day when he said, hey, corporations are people too, my friend?
Corporations are people, my friend.
Well, I mean, yeah, legally they kind of are. All corporate entities are their own distinct persons under the law, whether it's a partnership or an LLC or a trust or a corporation or even an estate. And here the plaintiff is an estate. Piccolo is the human for the entity, but he's not the plaintiff. He's its embodied representative. But the real plaintiff is the estate whom he represents. Do you want to know who will win this? You might think Disney, because they seem to have good lawyers who know what they're doing, and they probably thought through everything. But if that is your guess, I would encourage you to, maybe guess again, because Piccolo has the high ground here. Maybe he waived his right to be in court personally, and that's a big maybe. But the estate was not a party to the purchase of the Disney Plus subscription. And for that reason, this is simply not a strategy that should work against the estate. And I say that knowing full well that the legal system does in fact favor enforcement of arbitration agreements. But the parties to the agreement to arbitrate have to be the same as the parties in the lawsuit, or at least acting on the behalf of or for the benefit of those parties. And the estate of Dr. Tangsuan didn't sign the agreement to arbitrate. The dead don't subscribe to Disney Plus. Look, this decision by Disney is a PR nightmare. They look like complete jerks for trying to take this grieving widower out of court and into some secret arbitration process. It's a dumb move, and if they could roll back the clock, I bet they would. So you might be asking yourself, why would a lawyer file this motion? Well, I think I know the reason. Some lawyer somewhere inside the Disney orbit messed up, and they thought they could get this dispute moved to arbitration, but it's such a bad look. And if you look at how the terms of service stack up from the Disney Plus contract to the Epcot Center purchase to the restaurant purchase, you cannot draw a line from one to the next to the next. Look, we all know how this happened inside the restaurant. The waiter gets the message that there's an allergen issue. The manager knows there's an allergen issue. But if they don't communicate that to the cook, or the cook gets confused about which ticket he's looking at, it's just a cross-contamination issue, and it can happen at any time. And people with deadly allergies like these are always at risk of this simple negligence, which I'm not saying that anyone at the restaurant had like bad motives. It's just a dangerous situation. And Dr. Tangsuan, according to the lawsuit, had her EpiPen on her and administered it to herself, but it was not enough to save her. What are your thoughts on Disney's defense to these claims? Do you believe that signing up for a free trial of Disney Plus should stretch to this extent? Drop your pro se opinion down below and let me know what you think. And don't forget to subscribe. The only terms of service here on this channel are that you get free content updates twice a week. I'll see you soon. We need to break down how terms of services are normally terms of services. He didn't write the vague and unclear. And restaurant and Walt.